Hello, everyone, and thank you for joining me today for Probate Done Right, 6 Simple Steps. Hi, my name is Lynn, St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning, where we serve clients in Washington and Idaho. So I'm glad you joined me today. One of our goals at ELG Estate Planning is to try to help provide information and educate so people can understand more about estate planning and the probate process. So that's what we're talking about today. If you hear the term probate, you might have a strong reaction, and that's understandable. Probate typically is done after somebody has passed away. And if somebody has passed away, you are probably dealing with some grief, emotions. It's a very difficult time in people's lives when that person has passed away. So probate from the start may have some negative connotations. Add to that when we hear about probates, when we hear about them in the news, what we're hearing is about all these probates gone wrong, celebrity probates that go on for years for somebody that doesn't have a will, or probates that end up in litigation, family members fighting, millions of dollars at stake. So probates really do tend to get a bad rap, sometimes justifiably so, but not necessarily. So my goal today is to talk with you about probate, what it is, the simple steps to go through a probate process. If you're dealing with a probate right now, or are facing one, it is because a loved one has died. My sympathies to you. I'm sorry that you're going through that process. I hope you find what we're talking about today is helpful. Of course, at ELG Estate Planning, we help clients with probates. If there's anything we can do to help you, please contact us. We're here to help you. So when it comes to probate, let's start with what is probate. We're not going to take a whole lot of time. I will briefly address it, but we're not going to take a whole lot of time to say, why would you want a probate? Why in the world would you want a probate? I'll touch on it, but we're not going to spend a whole lot of time talking about why would you want it. Certainly submit your questions, but what we're talking about today is probate. The fact is that probate can be complicated, but it is far more simple if you have a good estate plan. Where do you start? What is probate? Probate is the legal process of settling somebody's estate. The estate of the decedent, what that means is the person who's passed away. In practice, what this means is that when somebody has passed away, if their estate is subject to probate, the will is filed with the court, a personal representative is appointed, they manage all the assets, gather up the assets of the decedent, of the estate, pay any creditors, and then they distribute the assets and file a document with the court that says that they are done. The probate process will take typically many months, though I know of probates that have opened and closed in one day because they were just trying to capture one asset. And it really is dependent, the time frame, about how long does it take to sell a home, for example, if that's going to happen, or file income taxes, or something along those lines. So it really depends on the assets of the estate. But that is what a probate is, the legal process to settle the estate and distribute the assets. Okay. Now, before I get into the 6 simple steps, excuse me for just one moment, what I want to talk about is why would somebody ever want to have a probate? This is estate planning considerations. I said I would touch upon it, not get into it too much, but why would somebody ever want to go through a probate? The reason for that, why somebody would want to, as opposed to a default, they go through it because they didn't do any planning, which is very common. Somebody would want to have a probate to make sure that their estate is properly settled. to make sure that their beneficiaries get asset protection. For example, a spouse against long-term care costs. To make sure that tax benefits are are received by the estate. To make sure that any future inheritance or estate taxes are minimized. So a probate can be an extremely powerful tool to get all these benefits that the legal system provides. So if you have an estate plan, you're going to be wanting to talk to your attorney about, is there benefits to having a probate of my estate? Now, your attorney should be telling you what those benefits are. So there are many times that we will recommend to our clients that their estate plan be set up so that their estate benefits from a probate, even though probate is a process, and whenever attorneys are involved, there will be legal fees to pay. It's just that the benefits of the probate far outweigh any costs in legal fees and in time. On the other hand, we often will recommend to clients, don't do a probate because it doesn't make any sense given what your situation is in your estate. For example, if it's a very simple estate and it can be distributed following your death by way of pay on death provisions of accounts, beneficiary designations, transfer on death deeds, then that may be the recommendation, is avoid probate by having your estate set up to just pay. Another way to avoid probate is through the use of a revocable living trust. The primary benefit of a revocable living trust is to avoid a probate process. So there are a lot of reasons, and it all depends on what your situation is, and we're not getting into estate planning considerations today. I'm happy to talk with you about it. We have a lot of videos on our YouTube channel, a lot of resources on our website at ELG Estate Planning to talk about estate planning considerations, and we're happy to talk with you about that. So what I want to leave you with right now before we get into the simple steps is there are reasons to do a probate and there are reasons to avoid a probate. We're not focusing on that today. What we're focusing in on, what are the 6 simple steps? Let's go ahead and get started. Step number 1, open the probate. What does that mean? How do you open a probate? Again, probate is a legal process. What that means is that it is in front of the court. So if you reside, for example, in Spokane County, you will, after your death, and if you have a will, the person you named in the will, they're called the personal representative. They take your will, they file it with the court along with what's called a petition to open the probate. That is how the probate process is opened. That is how it is started. Now, if you are trying to do a probate on your own, you'll find that the clerk of the court is not going to give you any legal advice. You likely can find forms online, petition to open probate and an oath, etc. If you're working with an attorney, likely they are drafting all those pleadings for you. So first step is to open the probate, file the will, file the petition. Who does it? The person in charge with this responsibility is the person who's named in the will. They are called the personal representative, or they are called the executor. It's the same thing. It's the person who is responsible for opening the probate and proceeding with the probate action. If there's no will, that means that nobody has been appointed by a legal document to say you're going to be responsible for administering the estate. So then what we rely upon is, what do the statutes say? And the statutes in the state where you reside will say who has the ability to serve as the administrator of the estate. Administrator means the same thing as the personal representative. So The statute in Washington, for example, will say that the surviving spouse has the right to serve. The adult children have the right to serve, and who has the right to serve, and I don't want to get too complicated, also depends on, is it all what we call community property, or is there separate property of the decedent? So there has to, when there's no will, it gets a little bit more complicated because you have to define what kind of property did the decedent leave, community or separate. If there's no spouse or no adult children, then more distant relatives then have the right to serve as the personal representative of the estate. Keep in mind that even if you are named in the will to serve as a personal representative, you don't have to. You can choose to decline to serve. Why would you do that? You might do that because you just don't feel that you have the time or the capacity, the ability to do so. So hopefully when you were named as a personal representative, the decedent spoke with you and said, are you willing to serve? And you said, yes, absolutely, I am. But sometimes people, they don't even know they've been named as the personal representative. And if you don't feel you have the ability to serve, you don't have to. Somebody else will step up, whoever is named next in the will, or even if nobody is named next, the court will appoint somebody to serve. What does that petition to open the probate look like? What it is it's giving a summary of the person who died. It says who they are, when they died, where they resided, who are the beneficiaries of this estate. And that means of the will and of what we call non-probate assets. So non-probate assets could be an IRA or 401k, 403b, life insurance. So it's not just who is named under the will who can be a beneficiary, but who is going to be receiving assets that don't pass under a will. So the petition will say, who are those people? The petition should also say who are what we call the heirs at law. Those folks are defined under statute to be who would inherit if there is no will. Even if there is a will, you still need to identify who are the heirs at law. So let me just give you a really quick example. An heir at law of a single person will be their adult children. If one of their adult children died and they left the grandchildren, then those grandchildren are the heirs at law. And even if those folks are not receiving under the will, they are called heirs at law. And in the petition, you're going to say who they are. And in a moment, I'll be talking about the fact that you need to give people notice, those folks notice that you've been appointed as a personal representative. Another thing that's in the petition, and this is really important and very much misunderstood, is whether or not the estate is solvent. That's really important under Washington law, because if the estate is insolvent, meaning the debts exceed the assets, the debts are greater than the assets of the estate, then the court is going to be much more involved in the probate process. It is going to be what is called an intervention probate, meaning that everything that is done is going to have the court's stamp of approval. That makes the probate much more expensive if you have a lawyer helping you. If you don't have a lawyer helping you, it's going to make it much more complicated and involved because you're always going to be in front of the court. Whereas in a situation where the assets are greater than the debts, then the court isn't involved. It is what we call a non-intervention probate, meaning the court opens up the probate by signing an order, but that's all that they do. The court's not involved after that. Yes, there will be pleadings that are filed with the court, but the court isn't involved. You're managing it yourself as a personal representative. When it comes to the assets, when we at ELG Estate Planning prepare the petition, we will typically say that the assets, that it is a solvent estate and that the assets exceed the liabilities by greater than $10,000. In other words, we don't say what the value of the estate is. We don't put any details. We just say, court, this is a solvent estate. And that's what we would put in the petition. All right, so we talked about what do we include in the petition so that the court will take a look at it and say, oh, here's the will. It's attached to this petition. Everything looks good. Nothing is causing the court to say, do we have a problem here? As the personal representative opening up the probate, you also need to sign what's called an oath. The oath basically is where you say, I'll do my job. I will, under oath, say I will do what the law requires me to do, and I am qualified to do so. There are no disqualifications to me serving. What might be a disqualification? People who are felons will be disqualified from serving as the personal representative. So that's how the probate is opened. Petition is filed with the will. The oath is filed. The court takes a look at it. The court signs an order. By the way, you submitted the order that says this probate is starting and everything is good to go. Congratulations, step 1 is done. You have opened the probate. Step 2. And this is where people get a little bit confused, especially if they're not dealing with or working with a lawyer who's helping them, because it is not common sense. How do you know what the next steps are? I will let you know that we do have resources available. And for those of you listening today, we're going to be sending you some of those resources about what step 2 and 3 and 4 and 5 and 6 is. But step 2 is to notify people and entities that the law requires you to notify. So now that you have an order signed that says you're the personal representative, you have 20 days to provide notice of your appointment to each individual who is named in the will as a beneficiary. You are also required to give notice of the probate to people who are the heirs at law, even if they don't receive anything under the will. The reason the law requires that is so that the people who are the heirs at law, but they are not receiving anything, have the opportunity to challenge your appointment as personal representative and the will itself. Sometimes will challenges happen because the will was fraudulently obtained at something called undue influence. It's to ensure that if anybody is interested and knowledgeable about this will, and they know that it was procured through undue influence, that they have an opportunity to challenge it. So this giving the notice is a great way to make sure that this is out on the table. If you're going to challenge this will, you've got to bring that challenge on right away. So you need to give notice of your appointment as the personal representative of the decedent's estate. In addition, you're going to need to notify some government agencies. In the state of Washington, it's going to be the OFR, the Office of Financial Recovery, and the Department of Revenue. Why would you have to notify them of the probate? Because there may be claims that the state has against this estate. For example, if the person who passed away was a Medicaid beneficiary receiving long-term care benefits, and let's say they were a single person, they still owned their house was never transferred or protected through estate planning, then what's going to happen is the state's going to have a claim to be reimbursed for the benefits that it paid. So giving notice to the state departments is a way that the state says, do we have a claim against either the decedent or possibly against a beneficiary? Maybe there's child support that would be due, for example. So you have to give notice to the state agencies. So that is step number 2. Right away, after you've been appointed, give those notices to the beneficiaries, to the heirs at law, and to the state agencies that you must, under the probate laws, give notice to. Step 3, gather up all the assets. Now, this is what probably takes one of the longest amounts of time when you're probating somebody's estate is now you become somewhat of a detective. If the person was well organized, maybe they had a nice notebook and they put all their important information in the notebook so you didn't have to go searching, that's great. But if they didn't, or even if they did, you have an obligation to find all of the decedent's assets. How do you do that? Well, you're going to look through their mail. And if this was a single person, you are going to go to the post office and say, please redirect their mail to my address. You're saying this because the decedent's no longer receiving mail where they used to live. You're redirecting that mail to you as a personal representative. Why? Because if there are bills that come in, you'll get them. If there are statements on life insurance policies, you'll see them. Basically you're getting that person's mail and you're going through it to see what's important. That is for what happens after their death, but go back through all of their records they kept. Find what you can find. There's also a way to agency or websites that you can research life insurance. Did the person have any life insurance? You're going to be looking to see, do they get statements from, any retirement, investment accounts? Another good place to find out information is to look at their tax returns from past years. And if they didn't have tax returns, that's kind of a red flag to say, ooh, should they have filed tax returns? And if they didn't, is there tax liability? Because if there's tax liability, you as a personal representative need to make sure that past taxes are paid, current taxes are paid, and if it's a large estate, that estate taxes are paid. So when it comes to that bit of the role that you're playing on with regard to taxes, you might want to work with a CPA, a certified public accountant, to make sure you do your job correctly. Other assets you're looking for, obviously you're looking for real property, where their house is. You're looking for, any deeds they might have for other properties, titles to cars, vehicles, and such. Other assets you're looking for, think about all the stuff that's in their house. If they filled out what's called a personal property list that accompanies their will, they may have filled out something that says this diamond ring goes to so-and-so. This silver goes to so-and-so. There could be a list that you're going to be following to divide up that personal property based on where the decedent said they wanted it to go. So this part of the job is making sure you know what all the assets are, and then you're putting them in a list, an inventory. And what you're doing is you're saying, this is the value of the asset as of the date of death. Now, how do you know what that is? For personal property, it's not so important because unless it's like an investment type, art or something. But if you're saying, well, what is this house worth? If you're going to sell the house, that's going to tell you what the house is worth. If you're not selling the house, let's say you're in a situation where, the decedent was your mom, you're getting the house, you're going to keep the house, you're going to live in the house. You're going to want to get what's called an appraisal of the house. Why? Because especially with property that appreciates, that goes up and up in value, especially depending on where you live, you're going to want to know that, okay, well, mom bought the house 50 years ago for $20,000, and when she died, it's now worth $800,000, because you want to receive the house at that $800,000 level. Because let's say you decide to sell the house yourself later, you don't want to pay capital gains, and the tax laws are very favorable to people who inherit property. There's an adjustment in the tax basis up to the fair market value, but you got to prove it. How do you prove it? You prove it through an appraisal if it's real property. So valuing the property, valuing the assets, gathering them up, totaling them is really important. That is step 3. Step 4, are there any debts or creditors? You need to evaluate and pay creditors' claims. Now, what do I mean by creditors? Creditors typically are people that are owed money by the decedent, maybe for hospital care, medical care, credit card bills, that sort of thing. Let's say it's a mortgage on the house. That's what we call a secured creditor. And regardless of whatever creditors processing you do, they already have a security interest in that house, and you're not going to get rid of that creditor claim, or that debt rather, because they're already a secured creditor before death. Let me just take a little aside right here, going back to the situation we talked about. Maybe you inherited that house and there's a mortgage on it. A lot of people get concerned. It's like, oh no, I'm going to have to refinance. Interest rates are really high right now. No, you don't. There's a federal statute called the Garn-St. Germain Act. And what it says is if you inherit the home and it's got a mortgage on it, you basically inherited the mortgage. The mortgage company needs to keep it with you. You don't have to refinance it. You don't have to go get a new mortgage. You now are the person responsible to pay the mortgage because you now own the property. So that's a little aside to tell you, if you inherited property with a mortgage, you don't have to refinance it. And do you want to? Well, it really depends on what the interest rate environment looks like. So high interest rates, no, you're not going to want to refinance it. Low interest rates, maybe you will. Talk to your financial advisor about that. So let's talk about the typical creditors that a decedent's estate has. Oftentimes it is credit cards. So what do you do? Remember, you went through all of their mail. You saw the monthly credit card statement come in. Then you want to give an actual notice to that creditor to say, here, if you've got a claim against this estate, you have to bring it according to the laws. And if they don't do so, if they miss it, if the credit card company doesn't do it right, you don't have to pay them. It doesn't matter if it's a $2,000 debt or a $20,000 or a $40,000 debt. If you did the notice properly, the credit card company didn't properly do their part, they are out of luck, period. That might be one reason you want to work with an attorney, to make sure you do it properly. There's more that I could say about creditor claims and how to extinguish those, but that's probably a subject for a different discussion on a different day. Give notice to the actual creditors, and also publish notice in the legal newspaper in the county where the probate is, or in the county where any real property is, to say, if you are a creditor of this estate and you don't know about who they are, I don't know about you, but if you're a creditor of the estate, you have 4 months to bring a creditor's claim. And if they don't, then they are out of luck too. So this whole creditor's claims process is to make sure that if there are legitimate debts that must be paid, they will be paid. If there are debts that you don't know about and the creditor doesn't bring a claim, they're not going to collect from you as a personal representative from the estate. And if there are claims that are in dispute, that they're going to be resolved. So you're making sure that whatever the assets of the estate are that you've gathered up, that you've tallied up, that you've totaled, that when it comes to, bringing to a conclusion the probate, you're able to distribute them without worries that somebody later is going to come back and being the creditor is going to come back and say, no, you shouldn't have distributed all that because I'm a creditor and I should have received it. You want to make sure that that doesn't happen. Protect yourself as the personal representative and the beneficiaries who are going to inherit. Make sure that there aren't any creditors. That's done through the creditor's claims process, which includes giving actual notice and publishing notice in the newspaper. So that's a really important part of the probate process, and it's a huge benefit to it, as well as to extinguish creditors' claims. I mentioned this before. It's worth mentioning again. Don't forget about the IRS. They are actually what's called a super creditor, which means you got to make sure you pay them. You're not going to get rid of their claims. So work with the accountant. Make sure that if there's any taxes, personal taxes due, like income tax liability, that it's paid. If there's any estate tax that is due, that it's paid. If you live in Washington, our estate tax level is 2.193 million. What that means is that if your estate is worth less than that, there's going to be no estate tax paid. If your estate is worth more than that, and that money goes to people and to not charities, then there will be an estate tax that is paid by the estate. So make sure if you're working with a larger estate that you're working with a CPA. Likely if you're working with a larger estate, you're working with an attorney too, to make sure everything is done correctly. If you are a married person, a married couple, there's different rules that the IRS has about when estate taxes are paid. So you're definitely going to be wanting to talk to a CPA and a lawyer to ensure not only that estate taxes are avoided, but future estate taxes are avoided. Step number 5, manage and distribute the estate assets. This is maybe the fun part. You gathered up all the assets, you know what they are, you know their value, you paid all creditors, you paid all taxes. Now you get to distribute the money out to the people or the entities that are supposed to receive this money. You're almost at the end of this process. You get to distribute out the money. When you do so, you are going to want to make sure that you get a receipt from the person who receives the money or the charity that receives the money, where they say, I've received everything I'm supposed to receive from this estate. I don't expect anything more. And I know that the personal representative is going to be filing some paperwork, and I don't even need notice of that. So you're going to want to get this receipt and waiver of notice of filing of the final paperwork in hand. And that is your protection to show that you distributed out the assets where they're supposed to go. Everybody who was supposed to receive them acknowledged it. Then you are close to being done. One of the things I wanted to say, and we talked a little bit earlier about timing of a probate. One of the reasons that a probate might take longer than just, the 4 months creditors period is that there is real property that needs to be sold. That typically, when it comes to looking at the assets, what takes the longest is selling. Sometimes somebody has not just one house, but they have, rental properties or investment properties. And, it may take a while, months, sometimes even years, before the property is actually sold. If that's the case, that's one of the reasons that the probate will stay open for an extended period of time. Another reason that the probate might stay open for a while is, let's say that this was a taxable estate and the state of Washington required the estate tax return to be filed and estate taxes to be paid. The state of Washington isn't necessarily the quickest to finalize and approve that tax return. So that could keep the estate open for months, if not a year or more after the estate tax return is filed. That's another reason that a probate might be open longer than normal. Just make a note that in Idaho, the state doesn't have an estate tax, so you're not going to worry about that. In Idaho, all you're worried about is the federal estate tax, which was just over 12 million at a federal level. So estates that are larger than that are going to go past tax-free, estate tax-free. So in Idaho, the probate process, I would say, is even simpler than in the state of Washington. All right, so we've gathered the property, we've distributed the property. What is next? Step 6, close the probate. Closing the probate is really simple, especially if you did everything I just talked about. Like in step 5, you got the receipt and the waiver from the beneficiaries. All you need to do now is to sign a few things, a couple of things actually. One is called the Declaration of Completion. In that document, you're basically telling the court, I did everything, I'm done. I filed a notice to creditors, I distribute out the assets. If anybody asked for an inventory and they were entitled to receive it, I gave it to them. All the assets have been distributed, we're done. So you sign that, that document gets filed with the court, and there's no court hearing on it. It just gets filed with the court, and the court's going to close out the probate. We also recommend that you file a declaration that you did your work with regard to reasonably ascertainable creditors. In other words, you went through that creditor process, and if there were any such creditors, they've been paid or their claims have been resolved. That is really to protect the personal representative as well, to say, hey, I did my work. Another thing is that if you as a personal representative are collecting a fee, then you would be putting in that declaration of completion what the fee is that you've received. If you're the sole beneficiary of an estate, you're not going to collect a fee. If you collect a fee, you have to pay income taxes on it. But let's say you're a professional PR. That means you're likely not listening to this video, but because you know your job. But let's say you are a person who's not a professional PR, and there's a lot of work, and you're one of many beneficiaries. You might want to collect a fee, because don't let anybody say that it's not a lot of work. Yeah, the steps are simple, but it all really depends on what the decedent's estate looked like, how much stuff they had, how many creditors they had, et cetera, how many properties need to be sold. So if you collect a fee, you put it on the declaration of completion. Keep in mind that that's income to you, and you're supposed to pay income taxes on that. Talk to your CPA about that. So final steps. Step 6 was you signed a declaration of completion, signed a declaration about the creditors. Remember in step 5, you got all those receipts and waivers of notices from the beneficiaries about you filing the declaration of completion. You file it with the court, you are done, period. You've done your job. Congratulations. And that's all there is to the probate. So those are the 6 simple steps to a probate done right. We have a lot of resources on our website at ELG Estate Planning, and you'll be receiving also resources from us, including what I just talked about, the probate done right, 6 simple steps. Also, I want to share with you what is called our probate checklist. This is a checklist that we go through with more details about how the probate is done. This checklist is something that we prepare for our clients, and we'll include in there, for example, the estate tax ID number. If there's a trust, the trust tax ID number. I didn't get into a whole lot of details about that today. So I suppose I should have at least said, if you're if you're collecting money, you've got to put it in an estate account. You need an estate tax ID number. So those are some resources we'd like to share with you. We've got other resources available on our website. And of course, I am happy to answer any questions that you have. Let me go to our question and answer box right here. Here's somebody that says, is it still in the RCW that you cannot have a prior felony charge against you, that you cannot serve in a PR capacity? That's a great question, and I am not able to answer that question. If you, questionnaire, know that there's been a change to the RCWs about a felon serving, I think your question is not just that they are a current felon, but that they were a prior felon. There's been some changes in the law that people who are prior felons, that their voting rights are given back to them. So possibly there's something in that statute about also serving as a PR. I don't know the answer to that. I do know that if you are a current felon, You cannot serve prior felon. I'm not so sure about it. I like that question. I like it when you stump me and I don't know the answer to that. Does a petition to open a probate need to be filed in the county where the person lived? Great question. No, it doesn't. It often is, but often it's filed in the county, maybe where it's easiest for the lawyer to do it, or a county that's easier to deal with. Kind of a little bit off of subject, but oftentimes, like divorce petitions were filed in Lincoln County because it was just easier to do it there. But we, for example, our main office is in Spokane, so we'll file probates in Spokane County, even if they lived in Stevens County, for example, because it's simpler to do so. So no, you don't have to file in the county where the decedent resided. Please repeat the name of the mortgage law rule. It is called Garn Saint Germain. Another question is, will we be able to access this recording later on? Yes, you will. We're going to send it to you, and we're via email, and it's also going to be on our YouTube channel and on our website as soon as it's finalized. So that'll probably be early next week. Oh, somebody already found the mortgage rule because we have the internet available to us. Where are form templates found for the filings and declarations? I have not ever Googled the form templates, but there are a lot of websites. There's a Washington probate law, for example, that likely has some good form templates. On our website, we actually have a handout about do-it-yourself probate, but we don't include any pleading templates. But there is Washington probate law. You might be able to find form templates there. You know, it's just like with estate planning. It's really not the document or the form that's the key piece. It's the understanding of how to do it. There are some really good websites that tell you do this, do that. And, you know, very possible that you can do a probate yourself, you know, and save some money. On the other hand, if you get it wrong, or if you don't understand like a nuance of the law or something, it can end up costing way more money. So obviously, I'm an attorney. My goal is to share information to help educate you, but I also wish to impart on you that having legal counsel can be very helpful and very cost efficient, saving a lot of money when it comes to the estate. In Spokane, what newspaper do we file notice to creditors? Spokane Valley is where it's filed. Sorry, I don't have the exact legal name. Okay, well, great. I think I've answered all the questions in the questions and answers. I hope that you found it helpful today. The 6 simple steps to probate done right. If we can be of any help to anybody who's listening or sees us to do probate, we do serve clients in Washington State. We have an office in Seattle, Tri-Cities, and Spokane. We serve clients in Idaho as well. We're here to help answer your questions and to help you through a probate at what we know is a really difficult time in life if you're dealing with a probate. So, all right. Well, thank you for joining me today. I appreciate your time. Take care.